Hello, everybody. We'll get started in about a minute. Hello, everyone, and welcome to the Environmental Law Institute's event, Community Lawyering for Environmental Justice Part 9, Air Permitting. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. I want to take a moment to thank all of you for joining us this afternoon, as well as give a massive thank you to our wonderful speakers for preparing a fantastic program for you all today. Today's event is the 9th part of our Community Lawyering for Environmental Justice series, which is designed for attorneys to receive continuing legal education credit through practical education about the practice of law in relation to environmental justice. We've created a worksheet to go along with this event, so please be sure to download the written materials from the event webpage. We'll post the link in the chat to that. You'll also be able to download our 2 presentations from our panelists as well, so you can look at the PowerPoint slides along with them. Take a moment to go over the continuing legal education component of this program before we get started. ELI is an accredited CLE provider in Vermont and Pennsylvania, so the program is automatically approved for 1.5 hours of standard CLE credit in those 2 states. ELI has not applied for CLE credit in any other states for this program. Please check your state's CLE guidelines to see if your state offers reciprocity with one of those 2 states. If you're seeking CLE credit in a state in which does not offer reciprocity with Vermont or Pennsylvania, you'll need to apply for CLE credit individually with your state. Within approximately 1 week of this program, we will email out certificates of attendance to anyone who requests one and fulfills the requirements. Certificates of attendance are used to verify attendance for CLE purposes, and in many states, attorneys can use these to apply for individual CLE credit. To receive a certificate of attendance, you must be online throughout the entire program. We'll be verifying this with our software's attendance report. You must also fill out the certificate of attendance request form after the webinar. This was sent out via email to all of you before the program, but we'll also post a link in the chat in case you missed that email. And then you must submit the correct code in the COA request form to verify your attentiveness. So we'll be reading a code out loud and posting it in the chat at some point during today's program, so be sure to write that down. Should you have any questions related to CLE, please contact us at cle@eli.org. Today's program will be recorded and posted publicly to ELI's website and YouTube page, so you can check it out later if you can't stay for the full program. Additionally, we will be taking audience questions at the end of the program, so please feel free to put your questions in Zoom's Q&A box as soon as you think of them. While the chat will be open for you to post your observations throughout the program, please put any questions that you wish for our speakers to address in the Q&A box, not in the chat. I'll now go ahead and turn things over to our wonderful moderator, Zoe Vogel. Zoe is currently a public interest legal fellow here at the Environmental Law Institute and previously served as a law clerk at ELI during the summer of 2022. Zoe received her JD with honors from Tulane University Law School, where she served as the editor-in-chief for the Tulane Environmental Law Journal, a student attorney with the Tulane Environmental Law Clinic, and an intersectionality chair for the Environmental and Energy Law Society. During her time there, she also held positions at the National Wildlife Federation, the Tulane Institute on Water Law and Policy, and Louisiana's Center for Climate Excellence. Zoe, I will hand things over to you to get us started. Thank you so much.
Awesome. Thank you so much, Madison. As always, a huge thank you to our education team, as well as to our panelists who are here with us today. For our event today, we will have about an hour of formal presentation and then half an hour of Q&A. As Madison mentioned, please submit all your questions using the Q&A function at the bottom of your screen. We will respond to them at the end, but please feel free to submit them as you think of them. Today, Today, we are welcoming Carrie Powell, Senior Attorney and Air Program Leader of the Southern Environmental Law Center, Meredith Pinkins, Senior Attorney at NRDC, and Taylor Billy, Environmental Justice Staff Attorney.
Zoe, I don't want to interrupt you, but your audio is a little garbled.
Yeah, or
There
more
we go.
goose. So sorry about that. We will begin with Carrie Powell of SELC, a nationally recognized expert in the Clean Air Act with experience in her own practice at EPA's Region 4 office in Atlanta and with Earth Justice and the New York Public Interest Research Group. Carrie has worked at every level to fight air pollution. As leader of the AIR program, Carrie is SELC's principal spokesperson on regional issues related to air quality and helps the organization develop and implement its clean air goals through cases and other initiatives with an emphasis on alleviating environmental injustices. And with that, I will pass it to Carrie.
Thank you, Zoe, and nice to be here today. I'm going to kick things off by talking a bit about generally environmental justice and air pollution permitting, and then get into the nuts and bolts of air permitting. You'll give me just 1 second. All right. So, siting of new and expanded facilities and oversight of existing facilities is of central concern to achieving environmental justice. The Biden administration has put out several guidance documents pertaining to how environmental justice should be addressed in Clean Air Act permitting proceedings. These guidance documents focus primarily on how EPA and states should go about identifying environmental justice communities and facilitating increased involvement in those areas. A key 2022 guidance is called Environmental Justice and Air Permitting, and it discusses application of the Civil Rights Act in this area and confirms that permitting agencies that receive federal funding must comply with Title VI of the Civil Rights Act to ensure that they do not discriminate either intentionally or in effect against persons based on the basis of race, color, national origin, disability, sex, and age. It establishes 8 principles that EPA regions should follow and that it recommends for states to follow, but EPA does not prescribe a single approach or methodology. If you engage in air permitting on behalf of frontline communities, you should be aware of these guidance documents. You should also be aware of how permitting dovetails with Title VI of the Civil Rights Act. ELI hosted a panel on Title VI of the Civil Rights Act not long ago that is available free of charge, and I encourage you to take a look at that presentation. You should also be aware that some states like New York and New Jersey have state environmental justice laws that were enacted over the past few years that impact air pollution permitting and can be very effective. So it's always worth checking to see what your state law provides. Today, I'm focusing on the nuts and bolts of Clean Air Act permitting programs. This is only a quick overview, and I'll admit that Clean Air Act permitting can be quite complicated. But if you're considering learning about air permitting so that you can work on behalf of overburdened communities, I strongly encourage you to dig in and learn more. There are so few public interest attorneys in the United States who are familiar with air pollution permitting and confident in reviewing air pollution permits. You will initially be quite intimidated and not sure whether you'll be able to identify all the issues that you should identify. And I'm just encouraging you to dig in and do the best that you can. When I first started reviewing permits 2 decades ago, I truly was cold. I didn't have anybody to turn to get help. But I reassured myself that the reality is that the vast majority of air pollution permits in this country are issued without any public involvement whatsoever. And likewise, very little involvement by the Environmental Protection Agency. So even if you just start doing a little bit, I can tell you that in most permits I have looked at, even at the very beginning, I achieved at least some improvement in those permits. You can do this too, and the more you do it, the better you'll get. I want to go ahead and before I get started on the nuts and bolts part, try to give you guys a couple of links to materials that I want you to pull if you decide to get more involved. This first one that I'm sending you is a link to a guide that I wrote about Title V of the Clean Air Act. It's 20 years old, so it's a little dated, but still mostly, especially since it was at the beginning of the program before much had happened, it's mostly up to date. And then I have one more link. This is a much more recent one. And this one, a second to try to get back to the chat. So I'm dropping this one in the chat. This is actually a guide specifically to all kinds of environmental permitting for petrochemical facilities, but there's a chapter in it on the Clean Air Act. And I say we, me and an attorney that was working with me in my private law office up until we joined Southern Environmental Law Center last September. We put this guide together, and it is posted on the Louisiana Bucket Brigade website as well as some other places. But this can be really helpful as you dig in, and it'll point you to other resources as well. So let's get started on our nuts and bolts. And I'm gonna actually, I haven't taken control of my slides, so I'm going to quickly see if I can, well. Okay, I'm requesting control and I think I have it now. Great. So before we get started on our nuts and bolts, I'll describe for you just that there's three basic kind of Clean Air Act permits. The first, of course, are these Title V permits, and these are operating permits. They are for facilities that typically have already been operating for a while before they get their permits. A facility doesn't even have to apply for this kind of permit until they've been operating for 12 months after construction. Some states will issue the Title V permit at the same time, but they don't have to. Most don't. And it's pretty common that you'll see a facility operating without a Title V permit for up to a few years and sometimes a lot of years, even though that's not supposed to be what happens. A facility is supposed to get a renewal Title V permit every 5 years, though. And each time that happens, the entire permit is up for review and the public process has to move forward, just like it would be when the permit was first issued. The other kind of permit is a new source review permit, and that's a pre-construction permit. So that'll be the first permit that you see. When I'm saying new source review here, I'm talking about major new source review. So those are for particularly large facilities and modifications that will significantly increase emissions. And I'll tell you more about that later, but these permits are supposed to establish the control requirements and also make sure that facilities don't degrade air quality or interfere with an area's attainment of federal ambient air quality standards. Finally, there's a huge category that I'll call minor source permits. And minor source permits are for, a lot of times they set up limits that keep facilities out of Title V or out of new source review. Be aware that a facility can be subject to Title V, but not new source review, or they can be subject to both of those programs, but they still get a minor source permit along the way when they make changes or modify. So turning back to my slides now. Oops, okay, I skipped a little bit too far ahead. Apologies, getting used to a quick mouse. So Title V is, it was only adopted in 1990. The Clean Air Act had, of course, already been in place for a couple of decades, but Congress realized that it was very, very difficult to figure out what a facility had to do to comply with the act. As this quote on this slide shows, that the quote from a court in 2008 describing that was saying that parties were left to wander a regulatory maze in search of the emission limits and monitoring requirements that might apply. sometimes people refer to Title V permits as kind of just paperwork exercises. They point out that they don't establish new requirements. While it's true that they are not really designed to create new substantive requirements, they are in fact incredibly powerful because they consolidate all of the facilities Clean Air Act obligations into one document, usually one document. Unfortunately, some states do it in a couple of different permits, but usually you see one document. It's when they say no new substantive requirements, that generally means no new substantive limits, but it still involves additional monitoring requirements, record keeping, and reporting. And the terms of the permit, unless they're specified as not being enforceable by EPA and citizens, the entire permit can be enforced if a facility violates. These permits are almost always issued by state environmental agencies, sometimes by local agencies like health departments that have received authority. Every once in a while, EPA is involved in issuing a Title V permit. EPA issues the permits directly on tribal areas and the outer continental shelf. So a major source for Title V is usually one that emits 100 tons per year of a regulated pollutant. Those thresholds do get lower when you're in an area that is violating the national ambient air quality standards. Another trigger can be hazardous air pollutants. The threshold there is always 25 tons per year of all of the regulated hazardous air pollutants, or 10 tons per year of a single one. And then there's certain other sources that get swept in for various reasons. So a powerful aspect of Title V is that it provides extensive opportunities for public involvement. There's, of course, a 30-day public comment period, at least a 30-day comment period on a draft permit. EPA then gets a 45-day review period, and they have to get that review period. During that time, if EPA concludes that the permit is deficient, they can object, and the state cannot issue the permit until they go back and respond to the objection. Unfortunately, EPA almost never reviews a permit during the 45-day review period. So I'll tell you right up front, if you're working on a permit and you would like EPA to get involved early, you may as well go ahead and alert them really early in the process that this is an important permit and ask that they engage in their own review. If they object to the permit on their own in that 45-day period, it is such a quicker process because the regional office of EPA has authority to issue that objection. It doesn't have to be briefed all the way up to the EPA administrator, and you're going to get quicker relief. So if EPA doesn't object on its own during that 45-day review period, there then is a 60-day period during which anyone who commented on the permit can petition EPA to object. And then EPA has to object if your petition demonstrates that there is a deficiency in the permit. They have to respond within 60 days. They never respond within 60 days. If they don't, it used to be that to get EPA's response, you had to file a notice of intent to sue and maybe even follow through with a lawsuit. Lawsuits, and attorneys who pursue them can get fees. And if you filed your comments on time, your petition on time, then EPA can, then you're going to win this case. So you usually can find an attorney who's willing to take it. If EPA denies all or part of your petition, you can challenge that denial all the way up to the U.S. Court of Appeals. So for newer attorneys that might be on this, listening to this presentation now, this is a really quick way to suddenly find yourself as a new attorney arguing before a U.S. Court of Appeals. And I can attest that that is exactly my experience. And it does feel incredibly powerful to have a tool where you can find a deficiency in an air pollution permit, one permit, and end up arguing about it before the U.S. Court of Appeals. So I'm not going to get into the details of what counts as an applicable requirement that must be addressed in Title V permits, but you can look back at the slides if you want. These are just some key examples that state has requirements that are in their regulations that have been approved by EPA that makes them federally enforceable. That's the state implementation plan. There are also federal regulations that apply directly to sources. Those are new source performance standards, maximum achievable control technology standards for hazardous air pollutants, and of course, new source review pre-construction requirements. So just a quick overview of how a Title V permit actually assures compliance with all of these applicable requirements. The permit has to include monitoring sufficient to assure compliance. And that is probably the most important thing in the Title V permit. And when you're reviewing a draft permit, that's the most important thing for you to look for is there actually monitoring, record keeping, and reporting specified that will allow you to determine whether the facility is complying with their requirements. Another thing that's required is prompt reporting of deviations from permit conditions. I have to say that tends to get kind of abused in permits, and it's a little bit hard to enforce, but the idea is supposed to be that the government and the public receives quick notice whenever there is a violation or a deviation, as they call it, from a permit. What you definitely get is every 6 months a summary of the monitoring results. And that summary is important to get hold of if you're looking at a facility's compliance status, because they have to identify any deviations. And then another thing that's tremendously helpful is states have to prepare a statement of basis that explains their rationale for the permit conditions. And that's really important because, A, it's really helpful in understanding the permit if they do it well, but also when you're reviewing a permit, a very common thing to do is say EPA needs to provide, the state agency needs to provide a reasoned explanation for the monitoring that they've selected. So if you point out that there's problems with that monitoring, you would argue they need to do more monitoring and maybe suggest particular monitoring, but say they also, whatever they select, they need to provide a reasoned explanation for why it assures the facility's compliance. So here's just a few things you might get out of Title V. As I already discussed, you might be able to get more frequent monitoring or a different kind of monitoring that makes it a lot easier to tell whether a facility is in compliance. I can tell you this is hugely helpful. I've been looking at a lot of permits for facilities in Alabama recently, and those are facilities that aren't subject to Title V, and it's really rough. There are many requirements where it's impossible to determine whether they're complying in Title V as opposed to solve that problem. Another thing that you might get would be just additional specificity if there's a vague requirement that needs to be further defined. And so an example here was an EPA order objecting to a permit in response to a citizen petition for a failure to define what counts as reasonable precautions for controlling fugitive dust from 5 different coal-fired power plants. And then another thing is getting a compliance schedule. A requirement of Title V is that if there's any facility that is out of compliance with a requirement at the time it gets its Title V permit, it must be subject to a compliance schedule. And that compliance schedule sets out remedial measures that have to bring the facility into compliance. And so sometimes you can get a schedule. And if you want more information about the sorts of things that you might get out of Title V, you can look through EPA's database of petitions and orders, which is linked to here. I'm going to pause for a minute and ask Zoe, how am I doing on time?
You are doing great. If you could wrap up in just a couple of minutes, that would be perfect.
Okay, well, of course, new source review only takes a couple of minutes, right? So again, quick overview of new source review. I already introduced it generally, talking about the different kinds of new source review. You're going to see prevention of significant deterioration requirements, which most Pretty much any major new source is going to be subject to PSD requirements. Those apply whenever a facility is located in or will be located in a place that is in compliance with the National Ambient Air Quality Standards. It requires that sources utilize the best available control technology, and it also requires that there be ambient, sort of an assessment of ambient impact to show that the facility won't cause a significant deterioration of air quality. The other kind is non-attainment new source review. Those are much stricter permits. They are only for areas that are not in compliance with the National Ambient Air Quality Standards, and only for the pollutant that they're not in compliance for. So what will happen is that a facility will be subject to PSD for most of the pollutants, and then non-attainment new source review for, one or two of the pollutants if the area is a non-attainment for those pollutants. So you'll see a kind of combined permit. Those facilities have to achieve the lowest achievable emissions rate for the pollutant that's a non-attainment. Finally, you're going to see these minor source permits, frequently called minor new source review. Honestly, that's where most of the battles are in my experience. Over the past couple of decades, there have been many changes to the federal rules, making it easier and easier for sources to get out of new source review, out of major new source review. And so you end up seeing everybody getting these minor NSR permits. Usually the focus on a minor NSR permit is to try to figure out whether they should actually be major. And so you're looking at their emissions calculations and looking at their various arguments for how they do things. So it's going to be a combination of legal arguments and technical arguments to say that in fact they should be subject to the major source permitting. So I'm going to quickly breeze through these, but just so that these concepts are in your head. When you do see a PSD permit, first of all, you are going to want to hire a technical expert for this because the technical assessments are pretty complicated. But generally they have to use either a top-down analysis, as this slide is describing, or something equivalent to it, where they're going through all the possible technologies, and then they kind of knock them out based upon infeasibility or economic or technical infeasibility until they get to the one that counts as that. I already mentioned that they have to do an air quality impacts analysis. Again, like the technology determination, to participate effectively here, you're really going to need to hire an expert pollution modeler. And let me back up just 1 second to tell you, on Title V permitting and commenting on minor source permitting, well, it certainly is helpful to have an expert. I can tell you that in my career, I've achieved a lot without having an expert because often I was working for organizations that didn't have the resources to hire them, and but we were still able to accomplish a lot. So I'm going to quickly move into a couple of things you can accomplish by participating in new source review proceedings. One thing, as I mentioned, is you might get a source that has been classified as minor and persuade the agency that they should actually undergo major new source review. And that would involve much more stringent air pollution controls. And so I've done a lot of work on wood pellet manufacturing plants, and one of those where that happened for us in our advocacy was the Drax Morehouse wood pellet plant that eventually did in fact concede that they were major. Later down the road, they decided to install a lot of controls that brought their emissions down below the major source threshold. But in Louisiana, they require that sources still stay in the program anyway, so they're still subject to the major source standard. But in any event, they reduce their pollution a whole lot by like 95%. Another thing that you might do, it's similar to this, is you might force a source that's trying to be minor to install much more significant effective controls to actually bring its emissions down below the threshold that would trigger a major new source review. And again, this is another wood pellet plant, this one in North Carolina, where we succeeded in requiring them to install much more effective pollution controls. And then another thing that might happen is that you just show that the technology determination that was made during the major NSR process was wrong, and they need to do a more effective pollution control technology. Every once in a while, you can derail a project altogether. And I have an example here on this slide of where once the facility was confronted with the fact that they were going to need to spend a whole lot more on installing controls and doing monitoring than they were hoping for, they pulled their application back. And so far, we never saw it come back again. So that's it for me. And I feel free to reach out to me. You can find me at Southern Environmental Law Center and look me up on my website. And I really encourage you to take a look at the materials that I link to in the chat. Thank you.
Thank you so much, Carrie. Briefly, before we pass on to Meredith, I have the CLE code for you all. It will also be put in the chat. The CLE code is capital CAA, lowercase permitting 0424. And again, the CLE code will be put in the chat for those of you who didn't catch it. Now, moving on to our next presenter, Meredith Hankins. As a senior attorney at NRDC, Meredith works to reduce pollution from the power and industrial sectors, using litigation and administrative advocacy to develop, protect, and enforce strong federal standards. Meredith has more than a decade of experience working with the Clean Air Act, beginning as a refining permitting engineer at the South Coast Air Quality Management District, and later as a Deputy Attorney General representing the state of California in challenges to Trump-era environmental rollbacks. And with that, I will pass it to you.
Thanks so much, Zoe. And thanks everyone for joining today. I know that Clean Air Act permitting, as Carrie mentioned, can quickly become I see a lot of people's eyes glaze over when I start talking enthusiastically about the Clean Air Act. So what I'm aiming to do with my portion of this segment is just to take a step back and talk a little bit about the context and kind of how big a deal NSR is in day-to-day environmental practice. I kind of come at this from two different angles. As Zoe mentioned, I started out as a permitting engineer working on refinery permits at South Coast, where I saw NSR as a thing that everyone tried to avoid. And now that I have been to law school and been practicing as a lawyer for a long time, I think about NSR as a key part of the Clean Air Act that can be really powerful, but has unfortunately been weakened through various loopholes with various implementing regulations. And so what I'm going to talk about is how some of those efforts have transpired. So I'm going to start out with just a little bit of, like I mentioned, taking a step back and thinking about NOx control at power plants. The primary control for NOx is its selective catalytic reduction. It's been around since the 1970s. You would think that since the 1970s, many plants would have updated or been replaced or somehow triggered NSR. But as you can see by these charts, which may be a little difficult to read, and I apologize for that, but there is a very large percentage of both coal and gas plants that have not installed any sort of NOx control. And they have managed that by avoiding triggering NSR. One of the problems with the way the Clean Air Act functions is that it was designed to not impose retrofit costs, but rather under the assumption that as equipment was updated or replaced, the NSR would be triggered, and then these new sources would have up-to-date pollution controls. But what we see in practice is very, very old equipment, pre-Clean Air Act, still operating today that has managed to escape NSR by never updating. When I was a permitting engineer at South Coast, I toured a lot of the refineries or inspected a lot of refineries. And to be honest, it's a little terrifying how old some equipment is at like major infrastructure in our country. And so one of the things that has made it difficult about NSR is that for existing facilities, it's only triggered when there is a major modification that causes some sort of emission increase. And as Carrie mentioned, there are several differences between whether you're in an attainment area or a non-attainment area, but the gist of it is you modify something, it causes an emission increase, under pre-construction NSR review, you need to address that emission increase either by installing backed or layer or something along those lines. And now you'll note that in the Clean Air Act statutory definition on the screen, it doesn't actually define what an emission increase is. It just says increases the amount of any air pollutant emitted by such source. Now, EPA has implemented that by defining it based on a significant emission increase, and they define that by reference to emission rates that are cumulative over an entire year. So a modification is triggered if a source's emissions over an entire year would be higher than they were prior to the modification. So again, annual emissions, total cumulative annual emissions. But many regulated industries have been trying for a very long time to change that trigger to the hourly emission rate. And so this is just a really great example here up on my slides about the way industry has really pushed for changes in NSR. Sometimes there has been a bit of a partisan slant in how EPA thinks about NSR. So in this case, Duke Energy managed to avoid NSR for about 15 years. They updated 28 boilers and did not go through NSR because their argument was even though these boilers were running more and increasing emissions on a cumulative basis, they weren't increasing their emission rate. They were just running more, but their emission rate was not increasing. So the Clinton EPA actually filed an enforcement action. It went all the way to the Supreme Court, which affirmed EPA's use of that annual cumulative trigger. And so I've highlighted these dates here because I think they are telling. The Supreme Court decision was April 7th, 2007. 1 month later, on May 8th, 2007, the EPA, now under G.W. Bush, issued a proposal to change that annual trigger to an hourly trigger, completely reversing the position of the Clinton EPA. That rule was not finalized before President Obama came in, but you can see the partisan swing in how NSR is treated sometimes. The Trump EPA, again, tried to make that same change from annual to hourly in the ACE rule, which was the Clean Power Plan replacement. That change was actually dropped and it didn't appear in the final rule. But you can see that this is a recurring issue. There are also frequently bills in the House that never make it out of committee, but are related to the same hourly versus annual. So in thinking about, what to watch for when you hear NSR, it may seem like this very niche Clean Air Act acronym, but there is a really big impact. And you can see that by how hard the regulated industry fights to avoid NSR and seeks to have the EPA enforce NSR in a less stringent way. For example, you see this op-ed in The Hill from very recently. This article was actually about how NSR should use an hourly trigger instead of an annual trigger. And my colleague from NRDC, John Walk, had a 30-something tweet long thread explaining why this was bad and would not actually modernize the clean air. Some other things to watch for on NSR. First, what if the Supreme Court ditches Chevron this term? The original NRDC versus Chevron case, argued by my NRDC colleague, David Doniger, was about NSR. EPA had made a proposal to weaken NSR. They wanted to allow facilities to bubble their emissions so that they could modify one part of the plant as long as the overall, without triggering NSR, so long as the entire facility's emissions stayed the same or decreased. Environmental NGOs led by NRDC challenged that rule. And in that rule, the Chevron doctrine was announced that EPA's interpretation of the Clean Air Act was owed deference. Well, if they no longer have deference on interpreting the Clean Air Act on NSR, that potentially opens the door to relitigate every single loophole and weakening interpretation that EPA has ever made on NSR, because none of it is clearly in the statute. It's almost all interpretations of that statutory language. So it's one of those things that I think you should be a little careful what you're asking for, because overruling Chevron here may actually have a benefit, an environmental benefit, in terms of statutes like the Clean Air Act. The original text is very stringent and has been weakened through regulatory. I certainly am not saying that reversing Chevron is a good thing, but it is, I think, there will be unintended consequences, and no one really knows what's going to happen. But I think NSR is a particularly interesting thing that could open a real can of worms if all of these cases that John Walk and David Doniger, my colleagues at NRDC, have brought over the last 30 years, maybe we bring them again. Another thing to watch for on NSR, you may have recently seen that Administrator Regan announced that the existing gas portion of their new greenhouse gas power plant standards was going to be delayed. Instead of being issued this month with the existing coal and new gas, they're going to take a step back and take a more holistic approach to pollution from existing gas, in part to address environmental justice concerns about potential co-pollutant increases at plants that retrofit with carbon capture and storage. There isn't a lot of detail yet about what this multi-pollutant strategy might include, but I know one of the things that we are thinking about at NRDC, and I've heard other groups thinking about, is an effort to get EPA to close some of these loopholes and start enforcing NSR a lot more strictly, to give, as Carrie talked about, a little bit more community input into these potential modifications and to head off any co-pollutant increases. I want to quickly wrap up because I'm really excited to hear from Taylor, but I listed just a handful of what I see as some of the most consequential loopholes that are still open, either things that are holdovers from the Trump and Bush administration, things that the Biden administration has weakened. So just Google these later. But thank you so much. And please feel free to email or reach out with any questions, and I will turn it over to Taylor.
Thank you so much, Meredith. So to conclude the formal presentation portion of this webinar, and again, please do submit all of your questions in the Q&A at the bottom. We will finish with Taylor Lilly. Taylor works to develop litigation to address disproportionate environmental impacts on vulnerable and marginalized communities. As part of this work, Taylor works with departments across the Chesapeake Bay Foundation to develop relationships with community leaders and grassroots organizers throughout the watershed. Taylor earned her JD from the University of Maryland Francis King Carey School of Law, where she worked with the NAACP and the Maryland Environmental Law Clinic, participated in a joint partnership between the University of Maryland and the Arava Institute, and worked with the University of Malawi Chancellor College of Law, Environmental Justice and Sustainability Clinic. I will pass it over to you, Taylor.
Thanks, Zoe. And just so everyone knows, I'm not using slides for my portion of the presentation, but I will be dropping a couple of links in the chat. So like Carrie and Meredith mentioned, the Clean Air Act has a reputation, a well-earned one, for being a really complex body of law, but I just want to emphasize that it is one of the best ways to get tangible public health and positive public health changes for communities. More often than not, a significant portion of the pollution burden that communities are bearing, it comes from air toxics and air pollution, and a lot of the facilities of concern will be seeking, whether that's federal permits or state permits, will be seeking those air permits. And it's a good way for communities to get engaged, like Carrie mentioned, and to get good protections, and even in some cases to prevent the development of facilities that will have a significant harm on communities. And so I just want to touch really briefly on national ambient air quality standards, because even though they aren't a Clean Air Act permit themselves, they are an aspect of the Clean Air Act that find their way into state permitting processes. So CBF and SELC back in 2019 engaged on a proposed compressor station that was seeking a state air pollution permit as part of the Atlantic Coast Pipeline project. There, the state, in determining whether or not to site this particular facility, looked to the National Ambient Air Quality Standards. Now, these are standards that EPA is required to set under the Clean Air Act, and they are meant, at the primary standards at least, to be protective of human health. And state regulators have seen that as a way to determine the appropriateness of a facility, whether or not they exceed the NAAQS. In this particular case, Buckingham County is a rural county. It has very few resources in terms of internet and emergency resources, but it is one that a lot of folks sought out for that particular lifestyle. And because of that, when the permitting process was moving forward, one of the frequent refrains that folks heard from state regulators was that people in Buckingham are breathing cleaner air than people in Richmond and throughout most of the United States, and their national ambient air quality standards for that region will not be exceeded by the proposal of this facility. And for that reason, they felt that it was fine to approve a proposed compressor station, despite the fact that it would be next door to several community members and disrupt the lives of a lot of individuals who had been on that land for, in some cases, generations, moving forward from their families. And pretty powerfully, the Fourth Circuit, when they considered this case, because it was an interstate pipeline project that made its way up to the Fourth Circuit on appeal, stated that national ambient air quality standards are not a sufficiently searching analysis of public health impacts in a community. Now, this was a powerful statement because not just in Virginia, but throughout the United States, state regulators are looking to NAAQS as a determining factor for whether or not a facility is appropriate. But despite this, they do remain a strong reference for a lot of regulators. Even after Buckingham came out, we saw that when Mountain Valley Pipeline was proposing their Lambert compressor station in almost an identical fact pattern as the Buckingham compressor station, the state regulators still looked to the NAAQS and said, we feel like this is a good indicator of public health, and the regulating agency, the Virginia Department of Environmental Quality, in that case, very strongly pushed for consideration of the NAAQS to be the standard for determining whether or not that facility was appropriate. Now, luckily in that case, the Air Board ultimately denied that permit, not only for the NAAQS, but for several other reasons, including that. But they still continue to be a prevalent piece. Even the FERC, in their consideration of a proposed compressor station in Petersburg, Virginia, said, we recognize the refrain from Buckingham that NAAQS are not a sufficiently searching analysis, but still feel that this is an appropriate facility. And that has been borne out in a number of citing cases and has emphasized the importance of building a strong record before the regulator to combat and counteract the idea that NAAQS as a standard are sufficient alone and reliable enough alone to prevent harm. Now, there's been a lot of excitement because of there's a new reduction in the proposed NAAQS from the Biden administration. Originally, the NAAQS for PM 2.5, particulate matter and soot, which is one of the most concerning pollutants for communities, has been moved down from 12 micrograms to 9 micrograms, which is significantly lower and also a reflection of public health concerns around PM 2.5. Now, unfortunately, and I'm going to put a link in the chat here, 1 second. Most of the United States is already in attainment for PM 2.5. And so these new standards, while they will have significant impacts for all of those counties that aren't in attainment, the dark green areas on the map at the bottom of that page, for everyone in the light green areas, that means that when your state regulator is looking against the NAAQS, it's likely that a facility will still meet that burden. And so that means that when communities and anyone who's looking to support them is advocating on their behalf, you'll still have to counteract that NAAQS standards with on-the-ground evidence. And so that increases the necessity to advocate for air monitoring. And also, like Carrie was mentioning in her section, this is a great place to get expert help and get an analysis of the facility. Often in state permitting processes, the applicant has a very lengthy opportunity to build a very, very long and solid record with information about what their proposed modeling is. And in order to counteract that evidence and go beyond just saying that the NAAQS aren't going to be exceeded, it's important to be able to balance that with community and advocate science where possible. There is a lot of really great community science out there and a lot of opportunities where other advocates have developed reports on PM 2.5 and the concept that there might not even be a safe level of exposure to PM 2.5 because of how harmful breathing in those pollutants is, especially when you're in close proximity. But it is really great to be able to balance out the applicant's evidence with on-the-ground information in the record early and be able to intervene. And that also goes back to the Title V permitting process, because while state regulators have a really great knowledge of what's going on the ground and ability to engage in a local ways, the ability to have EPA oversight and federal oversight and engagement in the process early on increases the likelihood and the chances of getting either a protective permit or having restrictions on a facility that will be protective for human health. And I will stop there.
Thank you so much, Taylor. And thank you so much to all of our panelists. At this point, we'll move into the audience Q&A portion of the presentation. So again, if you have any questions, please feel free to drop them in the Q&A box at the bottom of your screen. And I'll just sort of move through them as they came in. So starting, is anyone aware of any studies looking at wind events in relation to actual better air quality? The question asker is from the Southern San Joaquin Valley in California, and that seems to be the reality there.
The only initial thought I have is that EPA does have a number of rules thinking about how air pollution moves across state lines. There's a long series of rules that have been reversed and litigated throughout a number of administrations under various names. I think Good Neighbor is the current name, but I would imagine that there's some information in those rules about how, you know, wind impacts air quality and how pollutants are carried across state lines.
Great, thank you. All right, next, can anyone speak to how permitting is handled on tribal lands, whether it's the same or different, and what that process looks like?
I can speak to that. So it is different. There is a different set of, so first of all, it's possible for tribes to apply to get authority to run their own programs. But they haven't generally. It's possible that some of them have some authorities under new source review, but I don't think so. So I'm at a little bit of a disadvantage because I'm operating out of the Southeast, so we don't have the tribal reservations here that would have that. But in general, that's an area where EPA has authority to issue permits directly. So the regional office will have responsibility for that. Under Title V, that is administered under, so the regulations governing most states is 40 CFR Part 70, but the ones governing EPA is 40 CFR Part 71. It is very similar, but not identical to Part 70. And a key thing to be aware of is that, of course, you can't, on Title V, you can't petition EPA to object to its own permit. You have to go through the Environmental Appeals Board. And once you do that, then you can make your way into court. And the new source review permits operate the same way. So you'd have the Environmental Appeals Board as the direction that you would go to challenge the permit.
And there's a little bit of a follow-up question to that, but if you're familiar with the tribal authority rule, the question is, if SCOTUS overturns Chevron, what potential effect that would have on that rule?
I am not familiar enough with that rule to assess that. Meredith, do you know anything about that? No.
Yeah, likewise, sorry, I'm not familiar enough with that rule to know.
Another little specific one, not sure if you guys are specifically familiar with it, but the Clean Air Act Section 176C conformity requirements for new federal agency actions affecting air quality. Is that something that any of you have experience with?
I think conformity is super important. It's another like tiny little area of the Clean Air Act that people's eyes start to glaze over when I talk about it too much. But the conformity requirements under the Clean Air Act basically mean if there's a major federal project or a project that's getting federal funding, you need to demonstrate that that will be in conformity with the ambient air quality standards, that it won't worsen the air quality in the area. And so one of the things that we've seen it be used a lot for recently is highway expansions, which as I'm sure many people on this webinar know, making highways bigger does cause more pollution. And so you see in areas like the LA basin, where mobile sources contribute a lot to that basin's continued severe non-attainment, that the conformity requirements were actually part of halting some freeway expansions. I want to say it was the 710 expansion from 4 or 5 years ago, where conformity was actually really successfully sort of threatened by EPA and the LA, I'm forgetting the acronym for their local highways, ended up withdrawing from expanding the highway.
So a little bit of a broader question. How do we address facilities that lack air permits, but who have also been grandfathered in?
Well, that's a combination of mine and Meredith's presentations, I think. So in general, a facility should not lack an air permit. I mean, especially if it's a little teeny facility, maybe, but most facilities have some kind of an air permit. And so, and the grandfathering is only for new source review. There's no grandfathering from Title V. So if they're big enough, they're going to have an operating permit. And then most facilities, even if they're not subject to new source review, they are subject to requirements under the state implementation plan. And they may also be subject to direct standards under Section 112 of the Clean Air Act. Sets the is the authority for EPA to set maximum achievable control technology standards for hazardous air pollutants, and those apply to both new and existing sources. Of course, they're more strenuous for new sources, but they do apply to existing sources. And then a lot of times you'll have a new source performance standard that has been triggered somewhere on the line or along the line, even if a source isn't subject to new source review. So it's seldom that you're really going to have a plant that's not subject to anything. But sometimes you for sure find some that aren't subject to major new source review. And then, the only strategy is to advocate for better state regulation and pay careful attention to when they modify to see if you can force them into major new source review then.
Thanks so much. I have a question sort of building off of that. You mentioned state implementation plans, and I know state law has been important in your litigation, Taylor, as well. I'm hoping you all might be able to say a couple words about the importance of state law, both like how it works, like why it plays an important role. I know with wetlands specifically, we're seeing a huge shift where it's sort of the power is falling to the states with regards to stringent standards, and I'm wondering if we're seeing the same thing in the airspace as well.
So I can just speak briefly to state review of their own air permits. And so there's an importance there because that means that regulation of a proposed permit and a facility begins and ends in the state, and they'll look to their own laws to determine whether or not a permit is appropriate. And so engagement at the state level in some cases can be the only opportunity to get meaningful reductions in pollution and or prevent the development of an overburdensome site in a community. And I think that's why it's been important to see a lot of the legislative advocacy that's happened at the state level in an attempt to prevent an overburdensome siting in communities, but also encourage holistic review of proposed facilities when they're seeking air permits and water permits in some cases in communities.
I can jump in and add a little bit more, Zoe. So I mentioned really briefly in my presentation that there are state environmental justice statutes out there, and some of them are really good. So one of the best ones that I'm aware of is in New Jersey, a law that was passed in 2020. And that law, it requires, if a facility qualifies as an overburdened community in New Jersey, and they have like specific criteria that you would apply for that, it applies for permitting for new and existing facilities, though the standards are obviously somewhat different for the existing facilities. For a new facility, if the agency determines that the facility will have a disproportionately negative impact on overburdened communities, and they aren't able to remediate, to mitigate that impact, then they have to deny the permit. So that is hugely powerful and goes way beyond what we have under federal regulations right now. And I will say that under the New Source Review program, I think that there is, and EPA has identified room under the statute to do much more aggressive regulation that would require consideration of environmental justice factors, but they haven't done that. And I'm seeing no movement, no intention on EPA's part to move forward with that sort of thing. So for now, we are looking for the states to take the lead. Other states that have some kind of environmental justice statute that I'm aware of are New York, Massachusetts, Colorado, Oregon, Indiana, Michigan. Sadly, none of the states that I am working in have statutes like that, and I don't see them coming anytime soon. Virginia has a bit of one, although they retracted it. I mean, it's my understanding that they retracted it in part once advocates started to succeed on using it. So, that's a risk. But I'm certainly hopeful that at some point EPA will take action to give us stronger federal protections, because in a lot of our states where environmental justice issues are especially severe, we really can't rely on our states to do it.
Thanks so much. Meredith, I think you might have answered this in the Q&A box, but I'll just open it up for the broader group. What are the key pollutants we should be looking for or looking at for methane gas energy generation and storage facilities?
Yeah, thanks, Zoe. I meant to type my answer, and then I think I accidentally clicked answer live, so I will answer it live. What I wanted to give a shout out, I think I saw some attendees on here from EDF and CATF who have really done a heroic job leading regulation for those facilities. So there are brand new, just published last month, new regulations under the Clean Air Act Section 111 for new and existing oil and gas facilities regulating methane as a greenhouse gas. So the key pollutant you can look for is methane. And I'm sure that the folks at EDF and CATF can fill you in on any details on that.
Sorry, it's a little long. I'm reading this one through, but we have a follow-up question to the question about the tribal rule. Unlike this Clean Water Act, which codified that tribes can get treated as a state, in the Clean Water Act itself, tribal authority under the Clean Air Act is based on EPA's rule, which may be considered a delegation. Can you speculate what overturning Chevron may do for tribes on this issue?
Unfortunately, I just don't have enough familiarity with the issues. And when it comes to Chevron, I brought it up with respect to NSR because there is a lot of existing case law about NSR before the DC Circuit and the Supreme Court that relies on Chevron and could have a different outcome if the agency didn't have Chevron on its side. But I would have to look more into the specific language of the statute and the regulation at issue, because the question is whether it involves an interpretation from the statute.
Great. Are there any discussions about regulating mold? The question and answer asker has clients living in housing that causes them to breathe in more mold spores impacting their health. Is this included in the Clean Air Act at all?
The Clean Air Act, okay, I'm at risk of stepping in an area that maybe there's something there that I am not thinking about right now, but in general, the Clean Air Act is looking at outdoor air quality, not indoor. There may be some sleeper section of the Clean Air Act that hasn't been fully implemented. I'm not remembering right now, but I'm not aware of anything that would hit the mold spore side of the house.
All right, another question for Meredith. Does the proposed change to a project emission? Sorry, it's taking me a second to read the question. Does the project emissions accounting proposal address the loopholes you mentioned in new source review?
So unfortunately, it is the reverse. The project's emissions accounting rule itself is a loophole. It was a Trump era rule. And I'm actually going to pass it over to Carrie, who I think may know more about the current status. My recollection is that the Biden administration either hasn't overturned it or has codified it. I'll turn it over to Carrie for more detail.
So sadly, when it comes to air permitting, the Biden administration has not really been a star on this. They sort of, in some circumstances, are actually affirming Trump administration rollbacks, and in others, they're proposing to keep them, but to try to soften them, I guess is the best way to say that. So to bring everybody else into the fold on what we're talking about here, the NSR emissions accounting rule is yet another way that facilities can get out of new source review. And I'm going to explain how I'm seeing this particular rule, which is still final. It's still the Trump administration's rule. There is a proposal to what I'm going to call soften it that came out not long back, but it hasn't been published in the Federal Register yet. So the comment period hasn't started. But before I go there, I will explain the idea. So it's always been kind of in line with that case that Meredith was talking about, Chevron v. NRDC. It has always been the case that sources have been able to get out of new source review by sort of internally offsetting their emissions increase with decreases, so that they sort of apply this bubble concept called netting. The difference here is that under this rule that was promulgated under the Trump administration, the emission decrease that you're using to offset your emissions increase doesn't, under that rule, have to be enforceable. It doesn't have to be contemporaneous. It doesn't, I mean, like it doesn't check off any of the sort of safeguards that were supposed to be in place to make sure that it's real and that it will continue. And so one way that we're seeing that in the South is that there are a lot of power plants that are shutting down their coal-fired units, and they're building new natural gas plants, but they're doing that on the site of the old coal plants. Except for they're not agreeing to shut down the coal plant before they start up the gas plant. So this netting rule is letting the companies build these brand new gas plants and not go through new source review, which is completely and utterly alarming when you think about it, because the whole idea of new source review is to make sure that when you get a new source, that it's using the most up-to-date pollution control technology. The analogy I sometimes use is like when you buy a new car, you don't expect that like, oh, you know, this one gets 1994 technology. It's new. Like we're investing in this thing for decades to come. You know, maybe even like half a century or more, at least from what we've seen on these coal plants. We should, at a bare minimum, get the best available control technology and get all the, you know, air pollution modeling to see how it's going to impact ambient air quality. But we're not. And the way that they're getting out of it is they're using this emissions accounting rule. Now, if there wasn't an emissions accounting rule, would they figure out how to use some other loophole? Yeah, maybe, probably. I don't know. But you know what we're so now one thing that we're looking at is when you're defining a project, should you be allowed to say that the old plant that is going away is part of the same project as the brand new plant? I don't think so. But that's what we're faced with right now. So yeah, that's definitely yet another one of those things that makes fighting over whether a modification to trigger major new source review to be a really challenging area.
Great, thanks so much. I'm going to take us in a slightly different direction, turning more towards the environmental justice and advocacy side of the Clean Air Act. Starting with a question on the duration for the notice and comment periods being around a month. It's a very short amount of time to prepare permit challenges. How do organized and effective communities prepare a strategy to challenge a permit in such a short amount of time?
So I can take a stab at this really quickly. The answer is that they make a good effort, and sometimes it's pretty tough. There have been a lot of at least at the state level, there's been a lot of success in pushing for extended comment periods. And I think this is where coalition building and advocacy is a really big piece of that, because it's not just a singular request from one individual or one community group, where organizations like SELC and CBF and NRDC are also working on similar permits. There's often a coordinated push to advocate for that extended comment period that allows either for communities to have more time to consider what kind of comments they want to file, or determine whether or not they want to join an existing effort to comment. And I think that it's one of the things that nonprofits and other organizations can bring to public comment periods is encouraging that advocacy. In addition to that, one of the things that we saw a lot during the pandemic was that there was a push for a lot of virtual hearings. And when we're talking about proposals in rural areas, there's a lot of inconsistency in internet access that makes it hard for people who do find the time and are able to get their thoughts together within that 30-day comment period to even be able to get online and say what they want to say. And so I think it's a balance of building partnerships and also sort of a little bit of an onus on larger groups who do have the capacity and our job is to find a way to get comments in that 30 days to push to make space for communities who are attempting to build their own coalitions and get comments in and respond. And to the extent that we can share information and get stuff that's publicly available to everyone, that also helps the process.
If I can jump in too, I absolutely agree. There's especially for Title V, there's some ways that you can prepare, because you can never count on getting an extension. Some states are really generous about it, and some aren't. So for both NSR and Title V permits, that's going to be submitted. I mean, you might not know. In a few places, they take comment on the application. So you would see a public notice. Most of the time you don't see that, but you might come across it in other ways. Like SELC staff just alerted me yesterday of a permit that they found out through a FERC proceeding. Like they knew that the court was going to be doing this, or for what various reasons, that it's going to be coming out. So you get the permit application because there's a lot that you can find out from that permit application and go ahead and get a heads up about it. If it's a Title V permit, especially if it's a renewal, you can get the existing permit, which should be online. And usually the new permit isn't that different from the existing permit, so you can get ahead. And you can also, I'm gonna preemptively grab a question that's already in there, Zoe, which is about the 6-month monitoring reports under Title V. Absolutely all the reports under Title V have to be publicly available. Unfortunately, only a handful of states, I think, put them online, but they have to be publicly available. So you can request that they'll provide it to you. So you can go ahead and get a whole bunch of documents about existing and gear up for a comment period. You generally would know that, you'll know that a Title V permit is expiring. Something important for people to realize, though, is that if a facility submits its permit renewal application on time, then it can continue operating under its existing permit as though it hadn't expired. That's generally a good thing, in that we don't want the state, the permit to expire and then the source is chugging on along with no permit. But it can be frustrating when 12 years goes by and the facility still hasn't gotten a renewal permit. There is a legal option. You can pull various legal levers to push those renewals to come out, but it is a frustrating aspect. So if you know that there's a facility you care about, you can look and see how much time is left on it. And I usually tell people, call the permitting agency and figure out whether they're likely to renew it anytime soon. because there's no point in like rallying the troops to get ready to comment on a permit that doesn't come out for 4 years. And so, you know, usually the states will be reasonably open and to come out with that.
So there's a bit of a follow-up question to what you were just talking about, Carrie. Do you all have recommendations for how people can find information on Clean Air Act permitting activity in their community? Is that usually at the state level, or what sort of advice do you have for people who are interested in knowing what's going on around them?
So these programs are run by the states. In most states, you can get information about what's going on with them, including all the permits by going online. And then some states you can get lots and lots of information, like the state of Alabama. While I am unhappy about a lot of their permitting practices, they do put everything pretty much online, every correspondence, everything. So that makes it a lot easier. You know, in contrast, I am working in Shelby County, Tennessee, where they put nothing online, and they make you jump through a million hoops in order to file an open records request, and they'll only take it from somebody who is a resident there, and they often require you to go get stuff in person. We intend, by the way, to try to address that problem, but I'm just telling you that things vary a lot. I would also just encourage people to call up regulators. Just call them up and that, you know, and sometimes to make sure that I get past the public relations person, I'll even search notices for rulemakings at the state level or permits and just see who the staff contact person is and call them. Just call up the operator and ask for that person, because otherwise just getting straight into the person who's in charge with media outreach, they don't tend to know very much. But if you manage to jump through the right, you know, get the right number and get transferred to the right person, you might get a lot of information.
Great, thank you. So we have a great question that sort of teases at cumulative impacts, which I know is sort of a buzzword of the day, you might say. How does the Clean Air Act address co-located or adjacent facilities that are under different permits when the overall burden to that community is higher than the individual facility would impose on its own?
I can take a stab at an answer that also loops in another question about whether the same standards apply to all communities and how can environmental justice affect those. I think the way the Clean Air Act was intended to work, the NAAQS, the National Ambient Air Quality Standards, would help with that. So the idea of the ambient air quality standards is that they set a health-based standard, and then each region is deemed to be in attainment or out of attainment. And if a region is already out of attainment, if their air quality is that bad, then more stringent requirements under NSR will apply. So for example, the lowest achievable emission rate rather than best available control technology, which, yes, they sound the same, but are different. So basically like a more stringent look is put at facilities that are in that are already out of attainment and are sort of bad air quality areas. Unfortunately, the setting of the ambient air quality standards over the year has become somewhat politicized. And so there's some question about whether they are actually health-based anymore, if EPA, you know, ignores its science advisory board and picks a number based on what states will end up out of attainment instead of whether it's actually health-based. So I know that it is in no way a good substitute for cumulative impacts analysis, but I think it's one way that the Clean Air Act could, if properly implemented, help address disparities in air quality across the country.
If I could jump in, that particular question referred to adjacent and co-located facilities. And so that suggests there could potentially be a relationship between those facilities. If that were true, there's guidance out there on aggregation of emissions and when you have to consider facilities that are nominally two different facilities to be the same facility for purpose. I mean, one facility for purposes of new source review and Title V applicability. So it's always worth looking at that. I literally have been looking at a facility just last week, and I need to spend more time with it, but it's being regulated as two separate facilities. But literally it's all on the same property, and the units are patchwork of like, this one's this company, this one's that company, this one's this company. So it's two companies, theoretically, but they're patchwork all on the same property. And then it appears that one of those companies has no employees, doesn't file any of their paperwork. Like it appears to just be kind of a shell company, a way to get this facility into minor status. And so that's I need to look harder. So I'm not calling names here, but I'm just telling you, like, so much of this stuff, nobody's looking. And so sometimes it's really hard, and it's hard to defeat their claim that they're two separate facilities, but sometimes we find stuff that's just really wrong. And so I encourage you to, poke around and look broadly, and actually look at those facilities that are getting out of the major fiscal funds.
Yeah, and I'll also just note that oftentimes a lot of co-located facilities are too small to reach the level of consideration under the Clean Air Act, and so you end up back in that state permitting consideration and in the NAAQS consideration that Meredith pointed to. And I think also ties in a little bit of Carrie's answer because it's a small facility, and you're at the state level. There is a really big push on record development to get folks to consider what's happening at that facility next door on the same piece of land, especially if we're talking about a co-located facility that's just an expansion of an existing project. We're seeing a lot of older natural gas facilities kind of attempt to revamp their infrastructure, and that leads to the development of new compressor stations, the expansion of existing stations, and that is like an individual permit and a technically co-located facility. And so you, like I said, get back into the next conversation about whether or not the individual attainment area that one facility is located in is enough to be protective of human health. And to answer the same secondary question that Meredith was talking about earlier, the Clean Air Act and these public health standards are meant to apply to everyone, but not every community looks the same, especially in communities where you've got 7 or 8 co-located facilities within a 1-mile radius. We're talking about annual standards for a region, not necessarily standards that talk about the day-to-day impact of air pollution on a community that is across the street, even from a polluting source that might not take an area out of attainment, but will have significant health impacts on communities and people who live next door.
Awesome. Not that is awesome, but I think that's a really important note to end on. Thank you so much for making that point, Taylor. As we're reaching sort of the end of our time together, I'd like to give each of our panelists a couple minutes to sort of articulate any closing thoughts or reflections that you might have before we pass it back to Madison. So I will open it to you all.
I will just echo what I started with, which is we need more attorneys looking at permits. It's only a few years ago, I filed a petition before I came to SELC. I filed a petition on behalf of an EJ community in Oregon, and it was the first Title V petition that had ever been filed. And I got a call from like 6 attorneys from the Attorney General's office to talk to me about it because they were all worried. And I was trying to explain to them that this is just a regular part of the process. Like, it's all going to be fine. EPA is probably going to object to your permit and you'll get a chance to fix it. It's going to be fine. And in fact, that's what happened. EPA objected and they had to fix it. But what I'm pointing out is, for me, I'm in Georgia, so I tend to expect that places like Oregon have a lot of public involvement on environmental issues. Turns out they don't, right? There just aren't people that are getting knowledgeable about this and able to dig in and look at the permits. So if you have the ability to do it, I encourage you to carve out some time and start learning and start looking.
Yeah, and I'll just echo that to say that we've seen so many facilities make it through with bad permits just because there wasn't opportunity or awareness to engage. Almost every county and locality in the country has a different notice requirement. Sometimes we're seeing notice of these facilities come through on newspapers the day after Christmas. And so when we have increased numbers of people willing to engage on permits and keep an eye out for these things, it increases the chance that better permits will come through, but also maybe facilities that haven't done the work to deserve a permit will be delayed in that process, and also increases community support that because these facilities are being proposed in some cases in a really local level, there's a lot of burden on the individuals who live within it to mount the challenge and to get awareness and to get the issue before people like us who have the time to review a permit. And that's a large onus. Not everyone has the time or has a particular hobby and interest in trolling state regulatory websites to see whether or not they've actually posted online, if they do post online. And that is something that impacts your life and sometimes your children's lives for decades. A lot of these facilities end up next to schools. They add to cumulative pollution burdens where there are a lot of highways and truck traffic. And so just a little bit of engagement sometimes can go a long way. Sometimes really small questions like, how do you plan to pay to develop this facility? Do you have air monitoring protocols? Where is this modeling from? Are you basing this modeling on an airport air modeling thing from 60 miles away next to water? Just like small intervening questions that ask for more specificity can really change lives in some cases and protect public health and prevent the development and creation of more environmental justice communities that are overburdened and have a number of facilities that have 10-year, 5-year permits that will continue to roll on.
I think Taylor and Carrie have really covered the importance of local permitting. So I will just put a plug in for the sort of stuff at the federal level. You know, as I think I talked about in my presentation and Carrie talked about with the project emissions accounting, there is a lot of weakening at the federal level that makes it that much harder for local permitting challenges to go forward. And you know, what we've seen in the past 20 years is that the regulated industry pushes really, really hard for these during Republican administrations, and then the Democratic administrations don't really see it as that high a priority to fix. So these loopholes just end up going unaddressed, or as Carrie mentioned, you know, sort of softened. And so I think one thing that is really helpful is just telling EPA how much this matters and to not let it slip by, because there are really huge impacts on the ground for these tiny, obscure changes that EPA is talking about with NSR.
Thank you all so much, both for your time in this presentation, as well as your advocacy throughout your career. At this point, I will turn it back to Madison to sort of conclude with some logistics.
Thank you so much to our speakers, Carrie, Meredith, and Taylor, for joining us and for all the wonderful commentary you provided on such a complicated topic. We truly appreciate your time and energy. Thank you to Zoe for moderating and to Christine and Jack on ELI's Pro Bono Clearinghouse team as well for their assistance in organizing this webinar. And one last thank you to our audience for tuning in. We appreciate your engagement and all of your wonderful questions. As a reminder, for those seeking continuing legal education credit, please be sure to fill out our certificate of attendance request form. We posted the link to that in the chat. It was also emailed out to you. Additionally, we have 2 different course evaluations, one for attorneys in Pennsylvania and one for attorneys in other jurisdictions. We posted the link to the general course evaluation in the chat, and we'll email it out to you as well. And the PA attorneys will also receive theirs through email. Should you have any questions about CLE credit, please email us at cle@eli.org. Thank you all so much once again, and we hope to see you at future ELI events. Have a great day.